Question: does a probate proceeding prevent a bank from foreclosing on property? This is a question that comes up a lot with some of my probate clients, and I just want to address that right here and right now. So what happens is we have someone pass and they end up in probate. Unfortunately, we try to make sure that we advise our clients not to end up in probate, but if they do, oftentimes the biggest asset that they've worked their lives for is caught in that probate process, and that is the home or some form of real estate. And more often than not, it's encumbered by a mortgage, right? So the bank has an interest in ensuring that the mortgage payments are being made. So what do we do is, do we stop that foreclosure simply by filing a probate proceeding? Well, in the state of Florida, a probate proceeding will generally not satisfy or stay a foreclosure on a property owned by the decedent. So the bank can proceed with the foreclosure. So this is because the probate process is focused on administering the estate of the decedent and distributing their assets to the beneficiary, whereas the foreclosure process is focused on something different, on repossessing the property in order to satisfy the outstanding mortgage debt. So if the decedent had a will in place, the probate court will appoint a representative to oversee the administration of the estate. Sometimes this person is called the executor. And the executor is responsible for paying off any outstanding debts of the estate, including the mortgage on the property. So there's some work involved with ensuring that this asset is taken care of and not going to foreclosure. If the estate is unable to pay off the mortgage debt, the lender may proceed with the foreclosure process. However, there are a few circumstances in which the probate process may impact the foreclosure process. So, for example, if the decedent's estate is in the process of selling the property, let's say you got with a realtor and you say, you know what, I'm going to put this property up for sale and the proceeds are going to be used to pay off the mortgage debt, the probate court may grant a stay of the foreclosure until the sale is completed. So additionally, if the decedent's estate is disputing the validity of the mortgage or the amount of the debt, the probate court may hold a hearing to determine the merits of the dispute, right? So it is worth noting that even if a probate proceeding does not stay a foreclosure, the decedent's beneficiaries may be able to negotiate with the lender to avoid the foreclosure. So it is worthwhile trying to negotiate with the lender to ensure that there's some sort of arrangement made or a payoff being made. So for example, they may be able to come to an agreement or on a payment plan or negotiate a short sale of the property. So overall, it's important for the beneficiaries of a decedent's estate to understand their options and responsibilities when it comes to the mortgage on a property. All right, working with an experienced attorney and sometimes a financial advisor can actually help ensure that the process and any potential foreclosure proceedings are handled appropriately. We handle this day in, day out. Please reach out to us at any given time. Again, this is Marlon Brammer from the Brammer Firm, and feel free to schedule an appointment with us at any given time to discuss any of these things. But you have a blessed one, and I'll see you on the next one.